Okay, this next video looks to some slightly more advanced issues in the basic construction of Section 1332. Now, in the previous video, we ended with a very simple hypothetical of Mr. Moss suing Mr. Perry, which would supply an easy example of alienage jurisdiction under 1332 A2. One of the things I cautioned students was that for the basic hypo, that students should only consider the first part of 1332A2, namely the clause citizens of a state and citizens or subjects of a foreign state. And I said we'll talk about the subsequent language later on. Well, now's the time to look at that language, and we're going to illustrate it through a couple of hypotheticals. So let's think about that hypothetical. We have Mr. Moss, citizen of France, versus Mr. Perry, a citizen of Louisiana. Bound controversy is satisfied. Let's posit some additional facts. Here's fact number one. Mr. Moss has his green card. In other words, he's what's called a lawful permanent resident of the United States. That means he's on the path towards citizenship. He's been admitted for a lawful permanent residence. Here's fact number two. Mr. Moss is domiciled in, you heard it, Louisiana. All right. Now, before we look at the statutory language, let's think about the realities of this fact pattern. The defendant is a citizen of Louisiana. Mr. Moss is still a citizen of France, okay? He's not a citizen of a state. But Mr. Moss is kind of similarly situated to Mr. Perry. He's on his way to becoming a U.S. citizen. He's domiciled in the same state as Mr. Perry. Well, if the purpose of diversity jurisdiction is to avoid the potential of bias against non-citizens, then it's really hard to fathom why one would need a diversity jurisdiction. And in fact, when we look at the statute, we'll see that the statute indeed does prevent jurisdiction here. So look at A2. Now here's the main clause. If the only language in A2 is the main clause, there would be subject matter jurisdiction even when Moss is domiciled in the same state and is lawfully admitted for permanent residence. But we got this exception clause here. So let's consider this as a clause that modifies the main clause. In other words, if the first clause is the main clause, then the second clause is a dependent clause that modifies the main clause. Let's look at this. First, we have the word not, right? There will not be jurisdiction. When will there not be jurisdiction? Well, there's not going to be jurisdiction under this subsection. Which subsection? Well, we're in the subsection, A2. So there will be no A2 jurisdiction. In other words, no alienage jurisdiction if the claims between a citizen of a state and citizen of a foreign state, oh, that's what we have, right? Now, here's the key language, who are lawfully admitted for permanent residence in the U.S. and, another key word, and are domiciled in the same state. This word and in this context tells us that we've got to look at two conditions, okay? The first is the foreign subject, the foreign citizen, is one, lawfully admitted for permanent residence. In other words, the LPR, right? Mr. Moss is a lawful permanent resident. And this foreign citizen is domiciled in the same state. Same state as whom? Well, same state as the boom, citizen of a state. Now, just look at this for a minute. Look how I've cut it up. This is the kind of stuff that you want to do with your statutes, okay? Take a look at that and consider what we have here. We have Mr. Moz, citizen of France, versus Mr. Perry, citizen of Louisiana. The plaintiff here is a lawful permanent resident who's domiciled in Louisiana. Okay? Both conditions 1 and 2 are met here. Accordingly, even though the first clause would permit alienage jurisdiction, the caveat is triggered and it divests the jurisdiction that would otherwise exist. Now, what if we change the facts somewhat? For example, suppose that Mr. Moz is not domiciled in Louisiana. Suppose that Mr. Moz is not domiciled in Louisiana. Okay. Is there going to be jurisdiction? And the answer is yes, because under the statute, both conditions must be met in order for the dependent clause to divest jurisdiction. Now, remember, I said he's not domiciled in Louisiana. Perhaps instead he's domiciled in Florida. Okay, so Moz is a lawful permanent resident domiciled in Florida. Well, under those circumstances, the divestment will not occur. Why? Well, look at the statute. Condition number 1 is lawful admission for permanent residence in the U.S. That's met. The and is conjunctive. It's not disjunctive. Or, the word or is disjunctive. The word and is typically conjunctive. And the second condition, which must also be met, is that this foreign citizen must be domiciled in the same state. But here in my fact pattern, Mr. Moz, the plaintiff, was domiciled in Florida. Okay, well, accordingly, there would be subject matter jurisdiction. Why? Because we have a citizen of a state versus a citizen of a foreign state. That's met. We have the except clause, but the except clause doesn't get kicked in because even though the plaintiff is lawfully admitted for permanent residence, he is not domiciled in the same state as the opposing party. And you think about that, that kind of makes sense, right? That kind of makes sense. Why? Because if Mr. Moz is domiciled in Florida, okay, then he faces the same potential for prejudice if the lawsuit is filed in a federal court in Louisiana as would any Florida citizen. So the diversity statute applies. We do have alienage jurisdiction here. Okay. Now, what if it was the reverse, right? Let's suppose that Mr. Moz is in fact domiciled in Louisiana, but now he's not a lawful permanent resident. He's just someone who's a foreign citizen who's domiciled in Louisiana, but he's not a lawful permanent resident. And now here what I'm going to do is I'm going to let you look at the statute, engage in the same statutory construction, and tell me, is there going to be 1332 jurisdiction here, namely 1332A2 jurisdiction? Think about it. And the answer is going to be yes. There will be. For the same reasons. Because the divesting condition, the except clause, requires 2 conditions to be met. And here, only one of those conditions are met. Okay? The second condition. But we won't have divestment under 1332A2 unless both conditions exist. Okay. And now I want to try something new. Suppose we have a citizen of France sue a citizen of Germany. And the lawsuit is in federal court for negligence, seeking $1 million. Is there going to be 1332 diversity jurisdiction here? And I think the answer is pretty clearly going to be no. What about 1332A1? Is that met? And the answer is going to be no, because you have to have citizens of different states, states of the U.S. But here it's a citizen of France versus one who's a citizen of Germany. What about number 2? Is that met? The answer again is no, because you have to have citizens of a state, of a U.S. state, on one side of the V. Okay. Number 4, we're not really addressing here, and that's going to leave number 3. Is that met? And the answer is no, because it requires citizens of different states, states of the U.S., and in which foreign citizens are joined as additional parties. So let's go back to the hypothetical. Let's play around with this a little bit and see what we can get. Let's change the hypo a little bit. Instead of having France sue Germany, let's have 4 parties. Let's have the citizen of Florida and a citizen of France sue a citizen of Pennsylvania and a citizen of Germany. Okay, so let's go back to our suit. We've got Florida and France versus PA and Germany. All right. Well, how are we going to carve this thing up? Well, first, when we have a lawsuit, we want to analyze things claim by claim, party by party. Florida is asserting 2 claims. Citizen of Florida versus citizen of PA and citizen of Germany. Same thing goes with France. Citizen of France versus citizen of PA, as well as against a citizen of Germany. 2 parties, 2 claims each. Well, we want to go claim by claim and analyze whether or not each and every claim in the suit has subject matter jurisdiction. Start with Florida versus PA. Well, that's 1332. Which one? A1. It's a real basic case. Citizen of Florida versus a citizen of PA. It's a suit between citizens of different states. How about the citizen of Florida versus citizen of Germany? We know by now that's just alienage jurisdiction. It's 1332 A2. And the same for the suit between the citizen of France and citizen of PA. Again, 1332 A2. Okay, so we've got Florida versus PA, that's an A1. Florida versus Germany, that's a 1332 A2. Citizen of France versus citizen of PA. Again, it's regular old alienage, it's A2. The one that's hard is France versus Germany. And that's where 1332 A3 kicks in. Going back to the statute, remember, the claim between the citizen of Florida versus the citizen of PA was an A1. And then A2 gave us Florida versus Germany, as well as France versus Pennsylvania. Okay. The one we had the problem with was the claim between the French plaintiff and the German defendant. And that's where A3 kicks in. Threshold condition of A3 is you must have a claim between citizens of different states. And if you do, then you can add in citizens of foreign states as additional parties. Okay? So even though you can't have a lawsuit where the only claimants are foreign citizens, at least under 1332A2, you can have a lawsuit where a foreigner sues a foreigner under 1332, so long as the threshold condition is met, that threshold condition being citizens of different states. Now, what happens if we knock out one of our citizens of a state? Say, for example, the lawsuit is just Florida and France versus Germany. Okay, is this going to fly? Well, let's see. Florida versus Germany is okay, because that's a 1332A2 alienage. What about France versus Germany? Is that okay under 1332A3? Let's go back to the statute. What do you think? Is it going to be okay? The answer is going to be no, because we do have citizens of a foreign state as additional parties. The problem is the threshold condition here of citizens of different states is not met. Going back here, you can't have this, the suit between two foreigners, unless you have the threshold condition of a suit between citizens of different states. So this is not going to fly under 1332 at all. But of course, I keep saying this won't fly under 1332. 1332 is diversity jurisdiction. What if we have a federal question? Now, we haven't gotten to federal questions yet, but suppose this particular claim is one for copyright. So CRI, copyright infringement. Okay, and the plaintiffs are citizens of Florida and France, the defendant's a citizen of Germany. Is that going to fly? And the answer is yes, because 1332 is typically used for state law claims. Okay? However, if you have a federal question, okay, if the case arises under the laws, Constitution, or treaties of the U.S., then jurisdiction is premised. There's a number of provisions. Right now, I'm just going to talk about the basic federal question provision, which is Section 1331. Okay? Well, 1331, as we'll discover, doesn't require diversity of citizenship, doesn't matter what states or countries the party's from. All that matters is whether or not the case arises under federal law for purposes of the federal question statute. And we'll get to that in due course.